All right, yeah. I don't know what you're doing with your piercing in your tongue, but we don't need to see that. Want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. All right, so Miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, so you're going to have to speak up. Nobody can hear you.
I think it's just what I'm on. But yes, you can hear me.
Yes, slapping somebody who has dementias and Alzheimer's. This is just somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up.
Before we even press play, understand this. What you're about to watch isn't just a bad Zoom appearance or a judge having a rough day. This is a real criminal case involving an elderly woman with dementia and Alzheimer's, and a defendant who treats court like it's a group chat she accidentally joined. This case explodes almost immediately because from the very first second, the attitude is wrong, the respect is missing, and the stakes could not be higher. We're talking about a second-degree felony here, a charge that carries up to 20 years in prison, and yet the defendant shows up flicking her tongue-piercing, half-dressed, and visibly annoyed that the court expects basic professionalism. And that disconnect? That's where everything goes downhill fast. Watch how judge reclocks behavior instantly, how patience slowly evaporates, and how something that could have gone one way starts drifting in a very different direction. Pay attention to body language, tone, and effort, because in court, those things matter more than people realize.
Janisha Walton, if you want to appear on Zoom, you're going to need to have your video and you need to unmute. All right, yeah. I don't know what you're doing with your piercing in your tongue, but we don't need to see that. Want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. So if you want to continue to appear by Zoom, you need to appear appropriately dressed, and nobody wants to see you fiddling with your tongue piercing. All right, you're going to be back on June 2nd. And June 2nd, you can appear by Zoom, but if the court finds that you are not behaving appropriately, Zoom, that will be suspended. All right, thank you. It gets to be like 60. Oh my gosh, it's too cold. All right, so Miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, you need to put on a jacket or something, Miss.
We'll get that.
All right, Miss, you need to put on a jacket or something.
Oh, okay. You want me to call her and tell her?
Yes.
I'll text her.
All right, thank you. And I just sent her a chat.
Okay.
So if you just step to the side and I'll call you right back. And is this going to be an agreement or jury trial?
It's going to be an agreement, ma'am.
All right, so if you all will get the paperwork ready.
I have several courts to be in today. Could we do this on another day? I've got.
We're here, she's here.
Okay, and we can do it via, I believe she's in Chicago, if I'm not mistaken, at least Illinois.
All right,
That's fine. I can text you when the paperwork's ready.
Okay.
All right, so I'm going to put you in the waiting room and they'll get the paperwork sent to you. Ms. Ferguson will need your email and her email. All right, thank you.
Yes, Judge, we went through the paperwork earlier, so she's all set.
No, she needs to be sworn in.
Okay.
And if you go in that breakout room, the clerk will let you know if they have all the paperwork or if there's some issue.
Okay.
Please do not leave the room until someone requests you leave the room.
I know I'm trying to get back and join that room, but I don't know how to get back in.
Another room so it could pop up on your screen. And it's now room number 2. And are you Miss Walton?
Right here is where the warning lights should be flashing. Judges aren't just listening to words. They're watching demeanor, effort, and respect. And from the jump, this defendant signals that none of this is being taken seriously. The casual "my bad," the tongue piercing, the lack of urgency that might fly at work or with friends, but in a courtroom, especially when handling a felony assault against a vulnerable person, it's a massive red flag. Judge which shuts it down immediately because courts run on structure and accountability, not excuses. And notice something important. The judge isn't being harsh. She's being clear. This is a correction moment, a chance to reset. But instead of adjusting, the behavior continues. That's the problem. When a judge gives you an early warning and you ignore it, you're not just testing patience. You're testing credibility.
You need to unmute.
Yes.
All right, Ms. Walton, you have a right to appear in
It's
person.
unmuted. Can you hear me?
Yes. Are you able to hear us?
Yes, I can hear you.
All right, Ms. Walton, you have a right to appear in person in court, but I am in receipt of a consent to plea by video conference. Did you review that document with your attorney? Did you understand it and electronically sign it?
Yes.
Did you review the application for deferred adjudication with your attorney? Did you understand it and did you electronically sign it?
Yeah.
All right, so you're going to have to speak up. Nobody can hear you.
I think it's just what I'm on, but yes. You can hear me?
Yes. Did you review the true bill of indictment? You're saying yes?
Yes, I did.
All right, did you review that with your attorney?
Yes.
Did you understand it?
Yes, I did.
Did you understand you're charged with intentionally or knowingly committing bodily injury against a child, elderly, or disabled person at a state facility?
Yes.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. According to the plea, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant, the anger management course, and you're prohibited from practicing as a nurse in the state of Texas. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years and there be 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? All right, anything you wish to say on behalf of your client?
My client is in Chicago. She understands, she should not have slapped this individual. She does accept responsibility for it. She would just like to move on and be able to work and complete her probation without any problems.
This moment right here is more damaging than people realize. Showing up to court from bed, improperly dressed, sends a message, and it's not a good one. Courts expect effort because effort signals responsibility. It doesn't matter if it's Zoom or in person. When you appear like you just woke up, it tells a judge you don't respect the process, the victim, or the seriousness of the charge. And remember, this isn't about fashion or comfort. It's about judgment. Judges deal with hundreds of defendants. When someone can't manage the bare minimum for court, it raises a legitimate question. If this person can't follow simple courtroom expectations, how are they going to follow probation rules, reporting requirements, or no contact orders? These details matter, and they stack up quickly.
Supposed to follow probation rules.
All right, so how much training does she have in the field? Is she a licensed nurse or is she a person that somebody hires and says, hey, we need somebody to come in as a caregiver?
She will have to answer that one.
All right, are you a licensed nurse?
No, I'm working towards getting my CNA.
All right, so this is a situation where somebody just hired you to come in and work in a facility.
I'm a caregiver.
All right, so what's your level of education to be a caregiver?
I finished high school.
All right. See, this is what I mean. Everybody's just letting everybody be a caregiver. And the problem is that being a caregiver for somebody, I think that's sort of like a calling. You have to have said, you know what, I'm going into that field because you're dealing with people who have dementia, Alzheimer's, people who can't take care of themselves, people who need somebody to bathe them. The patient gets upset because they're not doing what they're allowed to do anymore. They can't communicate because they have dementia and Alzheimer's. Then everybody and their mothers just hiring random people, paying them minimum wage or less than. And then we end up here with somebody slapping somebody who has dementias and Alzheimer's. So I know y'all say she's prohibited from practicing as a nurse in the state of Texas. Okay, but she's not a nurse. She's not licensed to be a nurse. This is just somebody that somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up. And what was the name of this facility? Let me see. Chapters Living of San Antonio. All right. This is what the court is going to do. Does anybody want to speak to length of probation? The state is asking for 3 years. All right. Court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. There is to be proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with working with minors, no employment with working with people who are disabled. There's to be no practicing as a nurse in Texas or anywhere else. So I'm just going to say no practicing as a nurse. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, 120 hours of community service restitution. The $1,500 fine will be probated. There's to be anger management. I'm ordering anger management because you all agreed to it, but it just appears that you were a person who should never have been working with someone in any type of facility or young children or people who have mental health issues. That's just not a field for you. Good luck to you. Don't take any more of these positions that requires you to have patience and that requires you to be with someone who has dementia, Alzheimer's, they're elderly, they need somebody to be kind and patient with them. You shouldn't work in those positions. Do you understand?
Yes.
And I do fault the company that hired you as well.
This is where reality finally enters a room, because now the charge is spelled out clearly. Assault causing bodily injury to an elderly or disabled person at a state facility is not minor. It's not a misunderstanding. It's not a slap on the wrist offense. This is a second-degree felony, and the judge makes sure the defendant understands exactly what that means. 2 to 20 years in prison. That's life-altering time. And yet, even here, notice how flat the responses are. No emotion, no visible gravity, just short answers. Courts take note of that. Acceptance of responsibility isn't just saying yes. It's showing awareness of harm. And when that's missing, judges often compensate by tightening conditions to protect the public.